Hi, this is attorney Nicole Christie from the Christie Law Firm, where we work hard to make families stronger. Today I want to talk to you about DCF and Juvenile Court and the neglect petition process. This is just an overview. I can't get into specific details, especially as to each case. Each case is very different, but I want to give you a global overview as to what to expect from the juvenile court process when neglect petitions are filed. Now, when neglect petitions are filed, sometimes they're accompanied by an order of temporary custody. That's where DCF needs to remove the child immediately. Or sometimes they're just neglect petitions by themselves, where the child is still with the mom or dad or both, and DCF just has a concern. So initially, DCF will fill out several different forms. Much of it includes a summary of facts, which is why they're here, jurisdictional facts, why the court should take jurisdiction, a custody affidavit to note where the child is, a military affidavit to make sure that they show that DCF has looked for any parent that might be in the military. And that's important. So if you're in the military, DCF is supposed to make efforts to find you, because your rights as a parent can be impacted even if you're in the military and been deployed. So it's something to also look at when DCF files neglect petitions. So there is a series of forms that they file. Once they file that in the juvenile court, and prior to that, you have to understand, when DCF says, we're going to file neglect petitions, you get that notice from the social worker. It's a process. The worker has to complete the documents, it has to be approved by the supervisor and their program supervisor. Sometimes they'll have discussions with their attorney that works within the department, and then they file the neglect petition. So that process in and of itself can take a couple of weeks, if not a couple of months. So once they file and the court accepts the paperwork, they then prepare documents so that it can be sent to the marshal to serve you. And so one of the things that you need to understand, sometimes on television, it looks really cool. The guy, comes to the person's job pretending to be someone else and says, hey, you've just been served. It doesn't necessarily happen that way. Oftentimes they will give the documents to the marshal. The marshal will they will come to your house, they'll either put it in your hand if you're home, or just leave it at your door. So it's something to be aware of. The service, as they call it, service process, doesn't necessarily have to be in your hand. They can leave it at your door. So if DCF is filing neglect petitions, look out for large envelopes that might be at your doorstep. It's very important, because what will happen is the marshal will report back to the court, we left it at the abode, and that's enough to say that you were served the documents. And you could think, well, I didn't see the paper, maybe somebody picked it up, but you have to understand that they can leave it at your doorstep, and that's considered service. So when they leave the papers at your doorstep and you open it up, one of the first things you should see is, when is your court date? That is called your initial plea date. Nothing happens on that court date other than you're advised of your rights as a mom or dad or the legal guardian. And those rights include your right to an attorney, your right to have a trial, your right to cross-examination. So it'll go over the list of rights that you have. It's very important that you go to that very first court date. If you don't, you could be defaulted. And what that means is that the court could say, well, the person was given notice, they're not here, we're going to default them, meaning that they're no longer a part of this particular case, to the extent that we no longer have to provide notice to them. That'll stay until you actually get that vacated, if you do return to court, and then until the next step that happens with your child. So it's very important that you come to court so that you know what's going on that very first court date. So again, you are advised on that first court date, which is your plea date, of your rights. If there was an order of temporary custody, you would be advised of your rights at the first preliminary hearing of the order of temporary custody. But if there was no removal and it's just neglect petitions, the children are still with you, that first date is the plea date. And so a denial is entered. So with neglect petitions, there are allegations. You can either admit to them, you can deny them, or you can file what they call a NOLO form, which says, I don't agree, I don't disagree, but I will stand silent and let the judge find that the kids have been abused and neglected because I want the agreement that has been worked out with the department. And so that all depends on what the case is at that time. So after your plea date, during actually your plea date, you'll also get a date for what is called a case status conference. If you don't have an attorney, you'll be given still the date of your case status conference. I will point out that if you at that time don't have an attorney, the court is going to strongly encourage you to get one, either to apply for a court-appointed attorney, but if you couldn't find one, or if you're not eligible for one, give you time to hire your own attorney, one like me. So at that time, you need to understand that the court isn't going to feel comfortable without ensuring that you've been given a lot of opportunity to hire an attorney, because again, this has to do with your right as a parent, and you want to make sure that there's someone there to help you through this process, someone like me. So in that, after you get that court date for your next meeting, which is a case status conference, this case status conference is not with the judge, it's just with the attorneys and a court service officer. And there they just talk about the neglect petition. We at that point discuss, do we want to go forward with commitment, which means DCF takes guardianship and custody of the kids, or do we want to agree to protective supervision, which means that the court orders the mother or father or guardian to comply with certain specific steps, and if everything goes well, the case is over and the case is closed. If it doesn't, the judge can make a different decision. And so we have this discussion. Sometimes the cases are very complicated and we can't come to a conclusion, so we'll schedule another one. But nevertheless, this case status conference happens, and then there is a date for either a plea and disposition or a trial. So the plea and disposition, again, going back to you either admitted, denied, or filed a nolo. And so the plea, the court has to make a finding. They have to first make a finding of whether or not the child has been abused or neglected, and then they have a disposition. So if there is no agreement, then the court will order a trial. And at that trial, DCF will present its evidence as indicated from your advisement of your rights. You have a right to cross-examine all of those witnesses, to put on evidence for yourself, and to actually even testify yourself if you would like to. So if there is no plea, there is a trial, but there needs to be a finding of abuse or neglect. If there is a finding of abuse or neglect, then the court can make a decision as what we're going to do about this abuse or neglect. Do we want to remove the kids or allow the kids to stay with the parents and just supervise their compliance? And in either event, once that decision and disposition is held, then it all depends on what the disposition is as to what the next steps are. If the kids are removed, then it triggers this entire process of reunification, where there are court dates to make sure that there is progress with the reunification. And if there is no progress, what is the next step, whether it's going to be adoption or transfer of guardianship. If it's just protective supervision, there may be one more court date, and that's just to come back, and they call it an in-court review. Let's see how the process is going. Are things going well, or do we think we need to extend it? Could we maybe cut it a little bit short? But nevertheless, that in-court review is to look at the status. And if you get to the end of the protective supervision and things are fine, the court case is closed, and inevitably DCF will close its case. If the child remains in care and the child has been committed to DCF, then, like I said, there are these series of court dates to make sure that that child gets to a place of what they call permanency, meaning that they have their permanent home, whether their permanent home is back with mom or dad, or it's a permanent home with an adoptive parent, or a transfer of guardianship. One of the key things that I want to leave you with is whenever a child has been removed from a mom or dad, you have a very short window to get everything together and be able to be ready to reunify with your child. Unfortunately, that window doesn't really give people a lot of time to overcome lifelong issues, to overcome childhood trauma. But unfortunately, the system is set up that there is this timeline, and they're not going to allow kids to languish in foster care until a parent is completely ready. So I estimate between 6 to 9 months is when a parent has to make significant demonstration that they're ready for reunification, because the longer the child stays in care and the longer it takes for the parent to make progress, is the more likely DCF could get to a point where they decide, well, I think we need to move in another direction other than reunification. So it's just keep those things in mind. It's in no way to be a threat or to scare anyone, but it's to give you understanding. So in summary, it's very important to understand that when DCF files neglect petitions, it is a process. You need to be involved in that process from beginning to end. You need to exercise your rights. You need to exercise your voice. If you have an attorney, it's important that that attorney is representing you and they're representing what you want to see happen in that case. They may not agree with what you're saying, but they have an obligation to represent what you want to see happen in that case. If you don't have an attorney, I highly advise you to get one. If you can't afford one, you can apply for a court-appointed attorney. You may not have a choice as to which one, but if you're not satisfied with that attorney, you can always ask for another one. Whether or not the court grants it, it all depends. But it's important that you at least voice your opinion if you're not satisfied with your attorney. So if you need to learn more about DCF and dealing with DCF, please check out our other YouTube videos. We have a string of them. We have a certain playlist. We have playlists regarding investigations and the process. So we are here to help you, and while you may or may not hire us, we just want you to be sure that you understand when dealing with DCF, a lot is at stake. And so that's what our role is to make sure we can help kids by helping their parents. So stay tuned for more videos.